Very much, Mr. Chairman. First, let me welcome Mr. Higgins and say thank you. To date, your office has been very professional and forthright in their interactions with me and with my staff. And I would also praise the Commission because over the last 5 years, it's been very active in the pursuit of insider trading. I think you've charged now over 570 defendants in civil insider trading cases over that period of time. So it is easy for our constituents to understand insider trading when it involves a group of friends sharing information, maybe over the golf course or through an email exchange between them. It becomes a little murkier for investors, and I assume for the SEC, when the exchange of information is shrouded in contracts and it doesn't look like something that you have seen before. I am very interested in the Commission's process for looking at novel and creative deals to ensure that they are robustly reviewed to ensure strong investor protection and market transparency in places where people would try to use insider trading as part of a scheme. And I look forward to your answers to some questions on these issues this morning. And again, I thank the Chairman for holding this hearing, and I yield back. Thank you, Mr. Chairman. Again, as it relates to insider trading, as I mentioned in my opening, take, for example, a company that seeks to purchase another firm. We call the other firm the target. The company enters into a contractual relationship with a hedge fund to purchase the shares of the target for the benefit of the company before the announcement of the intent to acquire the target. The company and the hedge fund basically call their agreement a joint venture, or they call it a partnership. Does the existence of the contract somehow make what would otherwise be illegal trading by the hedge fund in the target company's stock legal insider trading?
Congressman, I obviously can't speak to any particular situations, but
right.
In general, there's, and I would also say that it's really the Division of Enforcement that handles insider trading.
Sure.
But I'm familiar with the law in the area. There's two rules under the Commission's jurisdiction that address insider trading. The first, Rule 10b-5, requires, in order for someone to be liable for insider trading under 10b-5, based on Supreme Court precedent, there must be a breach of some duty owed by the person trading to the source of the information. In the instance that you cite, if one company brought another company in, said, let's work together, I want to take this company over, I'll let you in on it, that wouldn't be any breach of any duty.
But let me throw in one other factor for your consideration before we get to the other caveat. Okay. What if the company had taken steps towards a hostile deal before entering into the agreement and the company and the hedge fund's interests were not aligned under the terms of the agreement?
Right. Well, on the taking substantial steps, the other insider trading rule is 14E3, which deals with tender offers. And when a bidder has made taken substantial steps to commence a tender offer, anyone who gets material non-public information from that bidder who trades on it is liable for insider trading, irrespective of any breach of a duty. So that's how 10b-5 and 14e3 work differently. I'm not sure I completely understood where the one person might be working at counter purposes to
why they wouldn't be aligned. In my view, they wouldn't be aligned because one party can walk away from the transaction at any time. The other party, the hedge fund, clearly is now tied into the agreement, is benefiting from the rise in the stock price as a result of the rumor being driven of the hostile takeover, right? So these interests are not, in fact, aligned.
Yeah, I mean,
and I'm also confused as to how this is any different than a couple of buddies out on the golf course, something we've seen a lot about. You know, something you've seen a lot, exchanging information. Are not sellers of the target's shares subject to the same imbalance of information as investors in a stock that is victim to a traditional insider trading scheme? I'd assume the fraud is the same regardless of the structure. And does this somehow, labeling this buying scheme a joint bid, insulate it from insider trading charges? That's my concern.
And that's a question that I don't think that either the Commission or the courts has answered on whether two parties getting together constitute co-bidders and
I'd also like to know what the SEC's process is for examining a novel or a creative deal structure, and what are the SEC's options to investigate conduct related to these types of transactions?
Well, if a filing comes in to the division, it would come in typically to us, either a proxy solicitation or a tender offer or a merger. We have criteria that we use to screen it if it meets the criteria, and we would look at it. And typically, hostile deals tend to meet our criteria for screening. We would look at it. We'd provide comments. We would review it against the applicable disclosure requirements as well as the anti-fraud provisions of our laws. Make comments to the participants and work through those, so that the goal always being that investors get clear, accurate material information.
Thank you. Thank you.